give depressing talks. So I try not to do
They're
that
always
this time.
interesting.
I hope it's informative. And so what I'm talking about is Civil Code Section 3333.4.
Oh,
You know what
yeah.
I'm talking about?
I've been thinking about that all day.
And it was interesting to me anyway that 19 and a half years ago, the voters, by initiative, voted for this. 77% of the people in the state of California voted for this initiative. And I think the reason why is because it's called the Personal Responsibility Act of 1996. I mean, who's against personal responsibility? You know, so of course you're going to vote for it.
Yeah.
And but the people who put this on the ballot were the insurance lobby, and so the findings and declaration of purpose. When I was preparing for this talk, I came across this, and I remembered this from the ballot pamphlet back in 1996, and I'll read it to you without editorial comment. Tell me if you agree or disagree with each one of these sentences. Insurance costs have skyrocketed for those Californians who have taken responsibility for their actions. Yes?
Yeah.
Yes.
Anybody say no? Okay, yes.
Our insurance gal's not here.
I know. Carmen should give me a big hug after
That's
this
right.
deal. Uninsured motorists, drunk drivers, and criminal felons are lawbreakers and should not be rewarded for the irresponsibility and lawbreaking. Yeah? True?
Yes.
Absolutely. However, under current laws, uninsured motorists and drunk drivers are able to recover unreasonable damages from law-abiding citizens as a result of drunk driving and other accidents, and criminals have been able to recover damages from law-abiding citizens for the injuries suffered during the commission of their crimes. Yes?
That's ridiculous.
It doesn't make you mad?
Yeah.
And so you vote for this, right? Of course. Californians must change the system that rewards individuals who fail to take essential personal responsibility to prevent them from seeking unreasonable damages or from suing law-abiding citizens. Therefore, the people of the state of California do hereby enact this measure to restore balance to our justice system by limiting the right to sue of criminals, drunk drivers, and uninsured motorists. Okay, so we get 33.4. And of course, based on that preamble, you want this law, right? To protect us from all these criminals from having the right to sue us.
Yes.
So, if you look at in any action to recover damages arising from the use of a motor vehicle, a person may not recover non-economic damages. Now, there's two kinds of damages, economic and non-economic. Obviously, economic are the kinds of damages that you can put a dollar figure to, like lost wages or medical bills. Those are real easy. Another damage that's an economic damage. I had a client who it was raining, so he put on his best hunting jacket when he drove, and he got in a wreck, and they cut his best jacket off of him. So that was a damage. We went to Cabela's and found out how much it was, and so that's an economic damage. Non-economic damage are the pain and suffering, the emotional distress, things like loss of enjoyment of life, and disfigurement, physical impairment, shock, indignity, embarrassment, apprehension. Those are all the non-economic damages, and you're entitled to both economic and non-economic damages under common law, under the code, under the Constitution of the state of California. And so what this code section here is saying is that in an action to recover from the operation of a motor vehicle, you're not going to get non-economic damages if any of the three things following are in place. The first one is that you're a drunk driver. So I haven't had very many cases in the 37 years that I've been an attorney where somebody came in and said, yeah, I got convicted of drunk driving and now I want to sue somebody that I hit. That doesn't happen too often. But that's what A1 is that if you're a drunk driver, you can't bring a case against somebody. B is if the owner of the vehicle is not insured. So if you're an owner of the vehicle, you better get insurance or else you're not going to be able to get non-economic damages. And then C is or 3 is the operator of the vehicle cannot establish financial responsibility. And this is financial responsibility is something that is defined in the vehicle code, and there's about 5 or 6 different sections that deal with what is financial responsibility and how you can have financial responsibility. And if you look at these code sections, the owner of the vehicle that is not insured or the operator who cannot show financial responsibility cannot get pain and suffering if they don't have those things. So, okay. So now, that's the code section. And then B is no insurance company. You know how those greedy trial lawyers are clever, and they'll figure out how to get an insurance company to pay, even though the code clearly says that if you're a drunk driver, or you're an owner, or you're an operator without insurance, you're not going to get it. Those greedy lawyers will figure out a way. So B says no insurance company is going to pay. And then C is, however, if you are an owner of a vehicle and you get hit by a drunk driver, you can bring that case. You get pain and suffering then. You get the non-economic damages if you get hit by a drunk driver and you're an owner. So when we went back and talked about the insurance costs going up and criminals suing, does this code section solve that problem? That's the code section. So the code section, this was called the Quackenbush Initiative. I don't know if anybody remembers that. Malik was about 2 years old when this thing. The Quackenbush Initiative, Quackenbush was the insurance commissioner, and he was bought and paid for by the insurance companies. And so it was his initiative, and then after this thing passed, and the insurance companies actually claimed that it saved them $327 million a year. There was a Rand Institute study that said that 13% of auto accident victims who were not at fault, because there's no fault involved with 33.4. 13% of auto accidents where the victim is not at fault would lose their pain and suffering. So, and the problem is that number will never be known, because when you have non-economic damages taken out of the case, this is really clever. What they did is they paid the doctors, because the doctors have a very strong lobby, and they don't want to cut the doctors off. So your economic damages are paid, you know, whether you have insurance or not. But if you don't have insurance, then the attorneys are not paid. And if the attorneys are not paid, I have people come into me every once in a while who don't have insurance. We find out that there's no insurance on their car, and I tell them, I don't want to take, you know, I have to take money out of your pocket. You know, it doesn't make sense. It's not in your best interest for me to represent you. Go do it yourself. The insurance company should pay your economic damages in this situation. Just because you're the owner of the vehicle who is not insured at the time, or you're the operator of the vehicle who cannot show financial responsibility, you then are not entitled to those rights that the California Civil Code and the Constitution afford you because of this code section. Now, how has that code section been implemented? There have been cases. I have only found one case reported in the state of California dealing with a felon or a drunk driver making a claim. And it was after this statute, and I think the attorneys took the case just to see if they... Yeah, just to see what the courts would do. And the courts, of course, said, hey, you're a drunk driver, you know, you're involved in a case like this, and they bounced it. So that's the only case I could find dealing with this issue. Just recently there was a case where, the name of the case is Briones versus Inc. And Briones is a 20-year-old kid, and he's going to work at 5 o'clock in the morning, and he's driving his parents' car to work. And Zink is a drunk, under the influence of drugs, runs a red light and T-bones Briones and puts Briones in the hospital. Briones has $740,000 in medical bills. So his life, he's on a ventilator for the rest of his life. His life is changed. He, Nationwide, just as a sideline, Nationwide was the insurance company for Zink, and it was clear that Briones was seriously injured. But Nationwide, as they often do, will say, well, you have to give us this and you have to give us that, and we're not going to pay you. The attorney for Briones gave him a an ultimatum: pay in 30 days or else we're going to sue you. And they didn't pay. And so they went to trial on the case, and Brioni's past and future wage loss was $1.35 million. So he's a 20-year-old kid with not much of an education. $1.35 million for the rest of his life isn't that much. But that was what the jury found for his past and future wage loss. $740,000 in past medical. Future medicals were $18 million. This kid's going to have 24/7 care. Past and future pain and suffering, $42.7 million. And punies, because Zig was a drunk driver, ran a red light, the jury found punitive damages of $62.5 million. So the total verdict was $125 million. Now, the attorney who argued this case asked for $325 million. And so the jury reduced what the attorney asked for considerably. So post-trial, $125 million verdict, and Nationwide is on the hook. They're going to fight this, they're going to live with this for years and years and years, but technically they are on the hook for the $125 million. And, but the first thing Nationwide does is they file a motion under 3333.4 because Brioni's parents neglected to keep their insurance in place on the car. And so if they had been driving the car, they would have been an owner who was hit by a drunk driver, and they could have collected pain and suffering. But because he was an operator and not the owner of the car, he's barred by 3333.4, and the trial court said, this is all I can do, this is the law. And so it's up on appeal now. It'll be interesting to see how that shakes out. But based on the law, Brioni loses $42.5 million. Now, and you think, wow, $42.5 million, so what? But when you're on a ventilator for the rest of your life, that can have an effect on the quality of life. One of the things that the attorney who's handling the Brioni's case said he could do is that under the vehicle code, until liability is established, he could have deposited $35,000. And there are people, some people do deposit $35,000 with the Department of Motor Vehicles, and that's proof of financial responsibility. So immediately after the crash, Brioni certainly didn't have the resources to do this, but somebody with resources could have deposited $35,000 with, if they'd known that Brioni's parents didn't have insurance, and then they would be okay. And in fact, there are some companies that have 25 vehicles or more, kind of a loophole in the laws, that if they have 25 vehicles or more, they have to submit to the DMV a proof of insurance once. And it's never updated, it never has to be followed up on. And the attorney who handled the Brioni's case actually indicated that he had 2 judgments against taxi cab companies that had more than 25 vehicles, and they had no insurance. And so he couldn't get a recovery from them, and there was no repercussions against them. So that's one of the problems with this law, is that, and it was challenged, the 3333.4 was challenged to the Supreme Court. And the Supreme Court came back, and it came back, this was in 1996, and I call that era the dark ages of the California Supreme Court. And during the dark ages of the California Supreme Court, they ruled against plaintiffs, they ruled against the people, they ruled for insurance companies, they ruled for big corporations. And they said that there's no due process violation here, that Brioni's or anybody who falls into the trap of 3333.4, that they don't have any due process violation, that they've had their constitutional and statutory rights taken away without notice, because you don't have to drive. You don't need a car. You can walk. That's what the Supreme Court said. One other thing they said is that our system works because people buy insurance and they put money into the pool, and so then when they make a claim, that's what their claim is based on, is the money that they put into the pool. And I wish Carmen was here, because I think she would indicate that that's not what really happens. But that's the argument that the insurance lobby made to the Supreme Court, and the Supreme Court allowed. So what are some of the examples of 3333.4 cases? Cabral is a case where a guy was getting out of his car, and he was standing next to, the door was open, standing next to his car, and he got hit by a bus. And because 3333.4 talks about out of the operation or use of a motor vehicle, well, you have to open the door if you're going to get in or get out. So that's part of the operation. You're close enough. So Cabral was denied pain and suffering because he was standing next to his car. Another case, Harris versus Lammers. Harris is standing next to her car, handing balloons in to her children in the car. And she gets hit from behind by a car and crushes her legs between the cars. She's denied pain and suffering because she did have insurance. You know, these are all either operators or owners who do not have insurance because, again, she's close enough. You know, close enough to the car. Allen versus Sully Motor was a motorcyclist, and he was turning around on a bus pad, and in the city, the city buses would park on a pad, and that's where they would have people come get on and off the buses. Well, the buses weren't properly maintained or weren't well maintained, and so they dripped a lot of oil. And so when he came along, the bus was gone, and he was just turning around, and there wasn't any bus there. And he hit an oil slick, and the oil caused his motorcycle to go out of control. And so he brought premises and negligence causes of action against the city. But he didn't have insurance. He was riding a motorcycle and just didn't keep up his insurance. And he was denied pain and suffering under the pool theory. And again, he could have been walking. He didn't need to ride his motorcycle. Chewed versus Jack in the Box. This is the old. This isn't the old coffee in the lap case. This is a new one in 2010. And Chewed actually sued Jack in the Box because he spilled coffee in his lap and had burns and all that. And his pain and suffering was taken out. And the appellate court actually said he should not be rewarded by not having insurance, by being allowed to get pain and suffering. Well, pain and suffering, again, is those non-economic damages that you're entitled to, that are part of your damages, but the appellate courts perceived those non-economic damages as being a reward. And also, Jack in the Box and Chewed is not putting money into a pool because he brought a negligence cause of action against that. It wasn't an auto case, it was a negligence case. So there's no pooling of resources in that situation. How about an employer who neglects to get insurance on his fleet of trucks, and either it's a secretarial snafu, maybe he screwed up, maybe a check bounced. At any rate, there's no insurance on a truck when there's a crash, and the truck driver brings a claim for pain and suffering. The defense finds out, hey, wait a minute, the truck didn't have insurance on it. This truck driver doesn't get pain and suffering. That case went up, and there's a vehicle code section that says that the financial responsibility laws have to be every driver or employer. So based on that or, then employees do not have to indemnify their employers by maintaining insurance. And thank God for oars, because otherwise, whenever your employer told you to take the truck or take the car, you would have to insure your employer's vehicle, or else you would not be able to get pain and suffering. Nakamura was a case where the defendant was driving under the influence and caused the crash, and the plaintiff pled, that he was negligent, that he was drunk driving, pled the economic damages, asked for non-economic damages, and because the defendant was drunk driving, asked for punitive damages. And the court said, sorry, you didn't have insurance, you didn't have insurance, and the defendant, who was drunk driving, pled his case down to a wet reckless. And so when it gets pled down to a wet reckless, if you notice the code section says that and was convicted of that offense. So not only does he have to be a DUI, but he has to be convicted of that before it can happen. So Nakamura lost his pain and suffering, he's still got his general, or his economic damages, he's still got his punitive damages, but not the others. Goodson, grandma and grandpa are 76 years old, and they have an old van that they own. And for some reason, they let the insurance lapse. They forgot it. Maybe they bought medication that month instead of buying insurance. Grandma is being taken to a doctor's appointment by daughter-in-law. And as they're going through an intersection, a truck blows the red light and hits on grandma's side and kills grandma. And so the heirs brought a lawsuit against the truck driver, clearly liable. The problem is that grandma was the owner of the vehicle and she did not have insurance. So they had a wrongful death cause of action. Wrongful death is kind of a hybrid that has both economic and non-economic. But when you have a 76-year-old deceased, it's not like she's providing a lot of income or support for the family. It's all emotional. It's all, she's grandma. And case thrown out, no damages. Now that was a case that occurred 6.5 months before 33.4 was adopted by initiative. Just recently, we have a new Supreme Court, and there's a new dawn that's coming with the new Supreme Court. And the new Supreme Court, very similar facts, almost identical facts. Daughter-in-law, though, has insurance. And so they said, oh, she's got insurance. It doesn't matter if grandma doesn't have insurance. And they said, and they remanded the case back and said, give them pain and suffering. So it just depends on, but it took 20 years. 20 years of cases like grandma's where they were denied pain and suffering before the most recent case. There's another case, this Polish immigrant, his wife couldn't get a license, she couldn't pass the license test. So when you tried to get insurance, the insurance company wouldn't give her, they excluded her from the policy. So she got involved in a crash, and sorry, no pain and suffering. You know, you're within 33.4. And then Landeros is a Kern County case where dad lets unlicensed daughter, she's 16 years old, he lets her drive his car, and he doesn't have insurance on it. But and so she's unlicensed, and he does not have insurance. But she's fortunate in that she's hit by a drunk driver, and this was a significant case in that she had serious injuries. Hit by a drunk driver, and so the court said that because she was hit by a drunk driver, the fact that she didn't have insurance, the drunk driver takes care of that, and so she can get her pain and suffering. And the insurance companies argued in that case that, well, she was unlicensed, so probably the insurance company would not have issued life insurance for her. And the appellate court said, well, more than likely is not evidence, and that doesn't prove anything. And so that they gave her pain and suffering. So those are the cases, and that's why I said Kramer should give me a big hug, because these are the things that owners have to have insurance, and operators have to have insurance. And this is a law that has saved the insurance companies $327 million a year since 1996. Have any of you seen the premiums go down? And so now these people, are they lawbreakers, as indicated by the preamble? And the attitude of the Supreme Court to say, you don't need to drive, you just walk. It is an amazing attitude. But we have a new Supreme Court, so hopefully that'll stop. One of the things too that Quackenbush was the insurance company's surrogate here. He helped get this passed, and so then after this passed, on the next election cycle, he went to the insurance companies and said, "Hey, I got that thing passed for you. Saved you $327 million. Come on, cough up some money. I need money for my campaign." So the insurance companies turned him in and to the Attorney General for shaking him down for extortion, and he had to leave the state hurriedly or he was going to be prosecuted. And he actually left California and left politics because the insurance companies ran him out. So they ran out a bad guy, but after they used him. Any questions?
Are punitive damages considered?
No, punitive damages are not, and punitive damages too are a different animal completely. It's like a third category of damages. Punitive damages are designed to teach the defendant not to do that. It doesn't matter, the plaintiff, they don't look to the plaintiff at all. They look strictly at the defendant and say, what's it going to take to teach this person not to do this? So the $62.5 million against Zink, the guy's a drunk no good. How does $62.5 million fit as punishment for him? I would think that will be appealed by Nationwide till the cows come home, because they're going to say that's an outrageous amount for this murder law. And under the law, they're probably right. If they had found punitive damages, and I don't know the facts or anything, but if they found punitive damages of a couple million, that probably would have been enough to punish normal people. It doesn't say that in 33.4, but the cases have interpreted it that way. Steve?
I got it. It was on the news recently about some guy that was shot while he was robbing somebody's home. The homeowner shot him and he's suing the homeowner. How do they even get that kind of stuff in the courts?
I don't believe that. I wouldn't believe that. There's also 33.2, I think, that if you're a fleeing felon or a felon in the commission of a crime, you cannot get damages. And there was a case up in Shasta County that a firm that I was involved in up there actually represented it. The school knew that the kids were going on the roof and stealing lights and throwing water balloons and stuff like that. And so they also knew that there was a skylight, and that after dark you couldn't see the skylight. So the kids ran across the skylight when they were stealing some lights off the roof and fell through, and one kid ended up being quadriplegic. So we brought a case against the school district, and the jury found, this is a dangerous condition. They knew that the kids were going up there. They knew that the skylight was invisible, but they found the kid like 80 or 90% negligent himself, and they only gave him like 10% of his award. So he ended up getting a couple $100,000, but he was in a wheelchair for the rest of his life. So that one, I had not heard about that
It was
one.
on the news.
Yeah.
And
Yeah.
there's another code section from 1986 that is 1431.2 is a code section that says that for medical bills, special damages, whatever percentage liability is joint, and that means that if Andy and I are co-tortfeasors, we both hurt somebody, and I'm the Bank of America and he's nobody. If I'm found 2% liable, then I'm liable jointly for the economic damages. And so if your economic damages are $5 million, somebody will sue Bank of America to get that 2% so that they can get the $5 million. In 1986, the insurance lobby passed laws that said that from now on, it's going to be several, and so that as to non-economic. So the pain and suffering it would go 98%, try to collect 98% of your pain and suffering from Andy who doesn't have anything, and I only have to pay 2% of the non-economic damages, and that's several. And so it's changed the law in some pretty unique areas. What happens now in some situations is that a defendant will claim that Andy may have been the tortfeasor, he rear-ended the guy, but then when the guy got taken to the hospital, the doctors malpracticed on him. And so then they try to say, we're only responsible for 98% of his medical bills, but the rest, the 2%, is responsible for the doctors. And the doctors have to pay for all this other stuff. And that's a case that came down just about 2006. And the insurance companies haven't pushed that, and I don't know why, to tell you the truth. But so the economic versus non-economic damages, that's been the way it's been forever. And then we have all these things where the insurance companies are passing laws in 86 and 96 to reduce the amount that they have to pay. James.
Weird question for you. So I know autonomous cars and vehicles are sort of coming into this new world here. Has there been any instance yet where there's been someone in violation of operating vehicle code who was involved in an accident in an autonomous vehicle where somebody was injured and trying to file a claim yet?
Not that I'm aware of. And there's one of our capital city trial lawyer attorneys and consumer attorneys in California. There's one of the attorneys is doing a lot of research and writing a lot of stuff about these autonomous cars. And he says at this point in time, I just read an article that he put out, he says, who knows what's going to happen. The legislature is going to have to get involved with this, and there's no telling who they're going to say is liable. Because the person could be sitting there reading a magazine or sleeping. How can you say that they're responsible? And so then you're going to have all sorts of, Toyota or whoever built the car is going to say, well, how can we be held responsible? Well, it's their car that malfunctioned. So it's going to be a real hard thing to figure out, and that may be one of the issues that prevents it from being used, going into effect quicker. Because we won't be able to know who's liable. The cars could be running over people at crosswalks. Yeah, who do you blame?
If it's not completed.
So any other questions?
Thank you, Mike.